Hi, everyone. I handed in a provisional patent application, for which I paid the $60, which was required to file at the USPTO. 2 weeks later, I got a note from the USPTO with a notice to file missing parts of a provisional application. And it says I need to pay an additional $300. So apparently the $60 counts as a surcharge for late submission. If anyone knows if this is correct or has an explanation, much be appreciated. Okay. Well, and so, being right up front, I haven't filed an application in a while myself. We have a paralegal team that does that. I will say the notice is usually pretty clear in terms of what is missing, hopefully. Usually when you submit an application for a provisional patent application, it is far less rigorous than a non-provisional. A provisional must have a specification and a cover sheet, and then I think a fee. David, I don't know if you have anything else. It's not much, and figures as needed. They're not required. Usually it's a good idea. So the specification is a fancy word for a written description of your invention. And, the goal there with the provisional even is to make sure that your invention is fully enabled. So you want to make sure it's written not just high level, but really laid out so that someone could go make it and use it. A lot of inventors make that problem, I should say, when filing on their own, is they're just not as detailed, and they usually don't cover a lot of applications or versions or other embodiments of what their invention could look like. So it's really just kind of this one narrow invention of what they've built, perhaps, or what they see as going to market. And really, a proper provisional should be very fleshed out, covered in a lot of different aspects. Without going too much further on that angle, I think that's it. It says a spec, drawings, and a cover sheet with payment. So, David, do you have anything else you might?
Just a practical bit, which is as soon as you've put something into the USPTO and your contact information is on it, you will be contacted. Not necessarily by the USPTO and not necessarily by people who care if you know that they are or not. So it's the ones that look really real are the ones that we need to be the most concerned about. The ones that are clearly phishing or spear phishing or whatever you want to say. Right. Those are easy to sidestep, not a problem, right? It was drawn in crayon. I'm just saying, just because it looks like it came from the USPTO, do what you can to make sure that that's a legit communication. When somebody's saying, oh, you need to give us $300 more, actually the USPTO usually says what you've done is insufficient, bam.
Yeah.
They're not going to tell you what to do about it. So I get suspicious immediately when it says, hey, just pay us another $300 and you're good to go.
I agree. Really? That's a great point. There's a lot of fraud. Matt mentions it more on the trademark side.
It's constant.
Gosh, it's just awful. The Bureau of Trademarks, right? No, there's just one. Make sure it's a government entity. I believe these marketing companies, they're required to have a statement that says we're not affiliated with a government institution. You got to read the fine print. Gosh, they look official. They all kinds of QR code scanners. You've got to read through it. One great way to avoid all that is just hiring counsel and just get it done right.
Yeah.
I run a marketing agency and would like to trademark my own company name. Plus, I have a client looking to file a few trademarks or the intent to use. I don't think any of the desired trademarks will be particularly complicated. One also includes a logo. Would love suggestions on attorneys or firms in California. Prefer something smaller, more personal than the big firms. Hey, I do know a firm. There's a couple of good firms here on this show.
I'll start by just saying, my trademark professor is not dead, but if he was, he'd be rolling over in his grave he's like, trademark is not a verb, but we use it that way all the time. So we don't trademark something. I will say immediately that trademark rights come from use. Trademark rights stem from use. The first step is using it as a trademark. If you're not sure what using it as a trademark means, putting it on your t-shirt right here is ornamental use, not a trademark. It's on the collar, or it's on the hang tag, or it's on the invoice, or the top of a menu, that kind of thing, or over a storefront. Remember back when we had bricks and mortar?
Yeah.
All of that's trademark use, and you need to have that, right? And they mentioned intent to use, which is cool. You get 6 months plus extensions up to 3 years as an intent to use application so that you're not actually using it in commerce. But ultimately, if you're going to have a registration, it's got to be backed up by using that trademark. So get out there and use it. Other than that, the very first step is not registration, not even close. The first step is a search. And you'll hear people talk about a knockout search, which is great. That's the next step past doing your own Google searches or Yahoo or Bing, or, whatever you use, which is also a good place to start. But what you'd really like to have ultimately, because of the value that a trademark is, and we can have a whole nother thing about that. But the trademark is so important. Don't spend any money on it. Don't get a vinyl wrap for your delivery van. Nothing. Don't do anything. Don't spend a dime until you know the trademark you're proposing is one you get to keep. So what you really want is a proper competitive analysis of the mark that you're proposing, right? Who else is using it? Who else is using something similar to it? Who else is selling snow tires, even though you're just selling replacement horns for bicycles? They might be related.
Yeah.
So, you need to understand what the competitive landscape is for the mark that you're proposing. So start with a search, and you need to have that use, because without the use, the registrations won't perfect, and they're assailable anyway. So
I have an idea for a very profitable and amazing invention. This would, I think, permanently replace all light truck bed covers and possibly an application for sedans and SUVs. But I have no clue as to where to start. I'll say that I made rough sketches of my idea, but all in all, I'm very green when it comes to building a prototype and drawing sketches. I want to submit a patent, but I have no idea what to do, how to get there. Any help would be much appreciated. Okay, well, I love it. Truck bed cover. I've been a truck owner, no longer a truck owner, but truck bed covers. I think they're kind of talking about a canopy or just any type of a cover on it. Can be quite important, especially if you run out of room in the cabin. You want to be able to store something and not have it get all wet. What I will say here is, to get started, one concept is, and this may be a sort of just a clarification. They mentioned prototyping. You don't have to actually ever prototype or build in real life your invention to get a patent on it. You've just got to be able to lay it out with words and drawings and convince the examiner with that it's been, it's novel, non-obvious, and has utility. So sometimes there is, and it makes a lot of sense, and a lot of cases to go build it out, make sure that it is and works the way you think it does. But if you're truly, concerned about the cost, or maybe the other side where you're certain it's going to work, and you want to just move forward and file the thing without having to, build it first, you don't have to, right? There's no more need to submit the actual invention. I think the only times they'll do that is if you're claiming a perpetual motion machine. They'll say, "Bring it in,
bring it on in."
Yep, love to see it.
A model of what you were going to patent used to be required way back.
Right.
Yeah. So that used to be a thing, but it's not a thing anymore. My other thoughts, because he was asking about prototyping. Sometimes prototyping is about finding out whether or not your idea is actually something you want to move forward with. And not all patent applications are intended to move forward with, right? How many times has a company got a patent almost specifically so that they could sit on it? They own it. They don't want it in the market. It's the disposable razor problem that you may remember, right? It's like, I don't remember what company it was, but they made proper old school razors, and then disposable razors started to come out and cut into those sales, right? So the idea was, well, we'll get a patent for a proper disposable razor, and we simply won't make it.
Got it.
Because it cuts into the sales of our existing product. So yeah, sometimes you need to know, you need to do the due diligence to find out that, because you want to build it, right? So you want to know that it works. So you're going to do some prototyping and da da da. As soon as I hear prototyping and da da, all of that stuff, my first thought is shut up, stop talking, don't talk to anybody. Period. I mean, it's the first piece of advice I give anybody is check out the statutes of limitations and don't talk to anybody. Those two things, right? And that's where you need to have the right kind of NDAs and things like that. These are the sensitive bits, and those things have to be in place before you start talking to somebody who does have the skill set to produce the trial products, so that you can evaluate them, do that prototyping.
Yeah.
That's not really an answer to the question, though. It's like, where do you start, right? But
Yeah. Yeah. I think it is. I think it is. Yeah.
Simply don't start until you know that you're not offering up your idea and starting that 1-year clock, right?
Huge points. Yeah, I think this was a simple question, but I think it's got really cool. We have a lot of different angles we could answer this. Trying to be simple is prototyping it, building it is very useful. If you use the inventor, need to prove it to yourself that the thing works.
Right.
Or yeah, that's huge. So if you can do it on your own, that's best. If you need to go to a third party to bring it about, make sure you have a very nice attorney-approved contract with a non-disclosure agreement to make sure that whoever or what company you're hiring to build it will keep it confidential. Because like you said, you do not want to start that 1-year clock, which is, hey, as soon as it's in the public or as soon as it's being sold, now you have 1 year to file it. And then the next thing is, while you're going through that process, make sure that it's, there's a sizable market. Okay. The biggest point about getting a patent is you want to make money. And so if you're going to be, going after something and it's such a small little niche, area of the market, you don't see you're going to be able to recoup your investments. You don't need a patent, right? You can go kind of have this hobby or kind of a smaller vision in terms of what your sales will look like. What are your goals? Kind of that, right? But the other side is that once you do convince yourself that you want to proceed with the patent, like David, you mentioned on the trademark side, do some diligence first. You want to make sure you do a thorough patent search to go see if, even though you think it's great and it's awesome and you can build it, has anyone else done it before? Or is it so close to something else that's been done before that it's not going to be worth going through filing?
Yeah. And a lot of your opportunities, China is actually getting easier to work with, not harder, but the regular NDAs that we might use here might not work there. Like the same document in China is called an NNN. So non-disclosure, non-compete, non-circumvent. So there's this concept. I didn't do it, but my uncle did because I circumvented it, right? So they just have to have additional language. And then you have to respect that those are just, it's just a different jurisdiction, right? I was saying that trademark rights come from use. That's not true in China. So if a trademark is involved and you're starting to engage with China, then one of the first things you might do is go and file for your trademark in China. It's another reason to make sure that you work with somebody who at least knows what to be worried about.
Yeah, issue spotting. Yeah, exactly. How much differentiation is needed to avoid patent infringement? And I will say patent rights are governed by what's written in the claims. For a utility patent, it's what the extent and the scope of the written claims. On the design side, it's what's in solid black line. What's shown in that drawing is the 3-dimensional article. What you've got to do, let's say on the utility side, to avoid infringement, hire an attorney to help you. Okay, but read the claims. If you're able to discern, what an attorney would advise you to do is they'd read through the claims, looking at the broadest claims possible, which are usually the independent claims, and break it out element by element. And so long as you are not meeting one of those elements, you're not infringing. And so that kind of goes to say the more detailed a claim in general, the more specific it is and the easier it is to avoid infringement. Anything else to add to that, David?
Just starts me thinking about how you're drafting them in the first place with those sorts of strategies in mind, right? We keep talking about, well, there's a lot of this stuff we can do by ourselves, right? As individual inventors or business owners trying to protect their trademarks. Absolutely. There's so much of this that you can do yourself. And JD, you and I can sit here and answer question after question after question and answer all of this stuff. We'll give away all of this information and knowledge. There's no way we can take anybody to law school. It's just not going to happen, right? So like you mentioned before, the issue spotting, but also partnering with somebody to get strategic about what you're trying to do. How should we draft these things? It's like the same thing in trademarks. Like, what is the description of the goods and services that I'm providing? And how do, as I add more, it gets more specific, it can. And then it's maybe that much easier for somebody who might be using something confusingly similar to say, yeah, but mine's enough different, I'm enough different that it's a different market. It's a different reasonable purchaser, that relevant purchasing public is a different group, or it's in a different channel, or these kinds of things to try and avoid that infringement. So you don't really want to open too many doors for folks.
Totally.
You can avoid that.
Yes.
But sometimes you have to get pretty specific and narrow, because you're trying to thread the needle between this cool patent and that cool patent. It's like, no, my stuff's right here. It's right here. So sometimes you kind of boxed in, and that's, you really do have to get specific. And that's what you need to do. And again, that's the guidance part.
Yeah, totally. The strategy, you nailed it. Yeah, it's not just that question. Your goal is to avoid being sued to begin with, right? You don't want to have to go through, even if you're right on the merits. You don't want to be so close, if you can, that it would even come up. So there's a lot of different scenarios and the practical advice that you can get when you hire an attorney that's used to looking at this sort of stuff.